manage with it in a different way, because
yes, there are
our basic history and the way we are used to do it. So my difficulty now is, in my opinion, conflict and dispute are more or less the same. So I would like to understand why conflict is as different meaning from dispute. From your general introduction, I haven't yet understood.
What I said at the beginning, that is, the literature is quite vast on that, and there is a unique approach to dispute or conflict. And I have reproduced here the approaches of those who I think are the major scholars on this subject, because in their work they have been very clever in summarizing the different approaches. But then it's up to you. I prefer to use the word dispute personally. I use the word dispute refers to all types of dispute, ranging from family to commercial to housing and so on, which involve very, two individuals or two groups of people I can easily identify. In the word conflict, I personally I agree with the idea that, you know, it involves large groups of people, two countries. But I'm aware of the literature, in particular dealing with the family dispute, and in particular, you know, the literature in psychotherapy, which the word conflict is used for those disputes between partners in family dispute. Okay? Then, for the social values and cultural identity, this applies to all kind of dispute. But different social values and cultural identity influencing the approach to a dispute don't mean that differences cannot be overcome. Okay?
Maybe that conflict is mainly bound to feelings. I may live also even a conflict with myself. Since I live a situation of conflictual. Instead, on the contrary, dispute is a struggle to obtain something. It's bound to objects. I have an aim, a goal, something to reach, to obtain. And the dispute to obtain the house, to obtain the custody of children and so on. This is my opinion, my sensation, my personal sensibility is toward this difference.
Okay, good.
Maybe.
So, yeah, from your brilliant comments, we can understand that still there is a clear difference, and this is what we have to aim to learn. Okay. Then there is I would like to introduce you to this concept of a polycentric dispute. A polycentric dispute is a concept developed by Lon Fuller, who is one of the father of the alternative dispute resolution movement. Are those disputes which involve more parties, more issues, more reasons for dispute, and the effects of a polycentric dispute are so-called waterfall effects, so influence not only those who were parties in the dispute resolution, but also other people. And the typical example of a polycentric dispute is the family dispute. Because even though we have two partners who actually decide to attempt mediation, Maybe these two parties have children, maybe these two parties have families, relatives. So the interests involved are more. So what we need to understand is that a polycentric dispute needs more attention, and the issues involved are several, not only legal. There are emotions, there are feelings, there are relationships, long-term relationships to take into account. So the polycentric dispute is a typical example is family, and in this we include also a dispute between same-sex couples. And we can argue that mediation can be the instrument for the resolution of those polycentric disputes. So this is a concept I introduce here but which can help us for our understanding of disputes involving same-sex partners we will look at in the afternoon. Okay, I have included some readings. Do you want me to repeat in Italian the first part? Yes or no? Don't be shy. No? Okay. I have included here some readings if you are interested. Okay, now let's move to something I'm very passionate for, and I'm in love with this amazing paradigm, the naming, blaming, claiming. Okay, we all know that disputes are complex, are not easy to understand. And the naming, so we need to understand the disputants. Who are the disputants? But also, before we attempt any kind of resolution ranging from the negotiations between lawyers to mediation to court proceeding and so on, we also need to understand the context in which that dispute arises. Why? Because we know that disputes are complex, meaning that there are several personal and social factors which influence, change the perception we have of what constitutes a dispute. But also, those factors change our approach to the resolution of a dispute. Personal factors. I don't think that we share the same idea of what constitutes an injustice, a wrong. Research shows that identity, personality, gender, emotions can influence our perception of the wrong. La nostra percezione dell'offesa, di che cosa costituisce un'offesa, cambia a seconda di fattori personali, ma anche social factors. Not only governmental policies, but also the attitude in some societies that disputes are something wrong, necessarily wrong, something to clean up. Well, we know that it's not like that. We know that disputes can be useful, in particular for understanding if in a specific context there are abuses. Only dispute can help us to understand if there are power imbalances of abuses of one person over another one, of one group over another one, or the abuses of a court over a specific group of people, abuses of the government over a specific group of people. Then there is also the availability of dispute processing structures. We all know in Italy, for example, that it's difficult. We all know about the delay of the civil proceedings. So this dysfunction is functions of the we find in the civil proceeding can limit our not only perception of the wrong, but also our intention to go ahead with the resolution of our dispute. Then there is, of course, availability of legal aid and instrument. It's possible that even though the wrong is felt, the resolution of dispute doesn't go ahead because the parties do not have enough money to afford to pay a lawyer, to file a case, and so on. Then there is also there is this difference between harmonious societies and litigious societies. There are societies in which we can include, for example, China, Korea, Thailand, Japan, which are harmonious society, in which the harmony of the society is a very strong value, and therefore is better to avoid dispute. There are, on the other hand, some litigious societies, and every time I ask my students to give me an example, they say the United States. Maybe it's not true, but in which the approach is, okay, there is a sense of wrong, we have to deal with that, okay, through court, through mediation, but we have to clean up the dispute. Then I would say that culture of machismo has limited and still limits the resolution of dispute of the, first of all, the perception of wrong, and then the resolution of dispute. And I'm sure that you all know about the case of women, several women, even in Italy, who think that abuses from their husband is something which is natural in their relationship, and therefore perceive to be, perceive hitting, insult, domestic abuse, verbal abuse as something normal. Hierarchy. Often in very hierarchical societies, those who live at the bottom of the hierarchy perceive as normal and therefore do not put forward any claiming when they've been abused by those who are at the top of society. Felsner, Abel, and Sarat, taking into account all these personal and social factors, argued that disputes are something social. So a dispute does not start when a lawyer is involved. A dispute starts in another moment. And they, based on research analyzing abuses towards women, but also the situation of poor groups of people in society, they created this paradigm which helped to analyze the process by which disputes are created. So the real starting point of a dispute is the injustice. So feeling the injustice, feeling the wrong. So in the naming, what we have is a person, an individual who feels that he or she has been victim of an injustice, of an abuse, of a wrong. So the first word is naming. Sì, io sono stato l'oggetto di un'offesa, di un abuso e così via. The second stage is the blaming. Is when we know who is the responsible for that injustice, for that wrong. So, secondo stadio, secondo passaggio è quando noi sappiamo chi ha commesso, chi è stato ad offenderci. And then we are the claiming. The final stage is when, after we have felt that we have felt the wrong, after we know who is the author of the wrong, then we claim. We ask for reparation. And if the author of the wrong apologizes or say, yes, I've been sorry for that, dispute is not created. But in the case the author of the wrong opposes to our request, then a dispute is created. So what is the important point of the naming, blaming, claiming? Is the so-called grievance apathy. We need to educate us and educate those we know to speak up, to talk about the wrongs and injustice they've been victims of. This has been very important, the grievance apathy and education against grievance apathy. It's been very important, I guess, I argue, for putting forward the rights of groups of people, the rights of those marginalized groups of people. I guess that for the LGBTI community, in the moment in which the LGBTI community in several countries, in several legal cultures, perceived finally that have been victims of abuses, injustices on the basis of characteristic of personality, they started to realize that that was the moment to put forward their request. And there, I think, started the idea to use the litigation strategy for the recognition of several rights. So even in a court case, in a family dispute involving same-sex partners, lawyers, mediators have this duty, in my view, to understand the underlying issues and help parties to become conscious about the wrong they've been victims of. Questions? Ripeto in italiano? Ok. Allora, all'inizio avevo detto è importante capire il contesto in cui una disputa si sviluppa, perché i contesti cambiano l'approccio alla disputa e cambiano l'approccio alla scelta del metodo per la risoluzione del conflitto. Si è tre professori americani, Felsner, Abel e Zarat, sulla base di studi empirici, in particolare osservazioni di donne vittime di abuso domestico e anche osservazioni di gruppi gruppi poveri nella società o emarginati nella società si sono resi conto che l'idea di disputa è una questione sociale, non nasce, la disputa non viene creata come dire, dagli avvocati, ma è sociale. E si sono resi conto che il momento in cui una disputa nasce è alla fine di questi 3 stadi, cioè la creazione della disputa attraversa 3 stadi fondamentali. Prima di tutto bisogna rendersi consci, bisogna essere consci dell'esistenza di un'ingiustizia, di essere stati vittime di un'ingiustizia. Il secondo stadio è il puntare il dito contro colui colei noi pensiamo sia stato l'autore dell'ingiustizia, e il terzo stadio è il chiedere, no? Riparazione allo sbaglio, all'offesa. Se l'autore dell'offesa si scusa e ammette di aver sbagliato, ammette che la propria azione ha creato una conseguenza negativa, va bene, non c'è disputa. Se però l'autore della disputa si oppone a questo, allora la disputa si crea e si passa allo stadio successivo di come risolvere la disputa, e la vedremo in pochi minuti. L'aspetto importante è questa educazione a educare le persone a svegliarsi dall'apatia dell'ingiustizia, perché ci sono molti fattori che determinano la nostra percezione di cosa può costituire un'ingiustizia. Quindi il ruolo dell'avvocato, del mediatore, dello psicoterapeuta è quello di aiutare le parti a capire, a rendersi conto, a prendere coscienza dell'essere stati vittime di un'ingiustizia. Questo è un processo che ha aiutato, secondo il mio punto di vista, anche movimenti sociali ed in particolare la comunità LGBTI. Nel momento in cui la comunità LGBT in diversi stati si è percepita come gruppo, ha percepito di essere stata discriminata sulla base del niente, e quindi nella fase del naming, e ha capito anche chi è stato o chi sono stati coloro che hanno discriminato la comunità LGBT. In questo rientra il singolo individuo come lo Stato. È iniziato il claiming, e il claiming è poi sfociato in diversi metodi di risoluzione, dalla causa intentata contro un singolo individuo alla litigation strategy, al portare in corte, davanti alle corti supreme, leggi che discriminavano sulla base dell'orientamento sessuale e così via. Quindi io penso che il valore di questo paradigma è un valore propulsivo per un riconoscimento e applicazione dei diritti umani.
If there are these 3 stages, and after that the person who knows he is the wrong one not recognize really this problem, so he said, sorry, I'm apologizing, and stop. How the other one, so the victim can go along his way. So how these people can wake up and say, oh, I am not to be apathic. So I don't know if my question is clear. So if there isn't a dispute, how to go along this?
You mean how to educate people to become conscious?
No, yeah. If there isn't a dispute, if there is a problem, in itself, because the victim recognizes the injustice and the other one not. Mm-hmm. How to superate, I don't know, how to overcome, yeah, the apathy.
Different techniques ranging from information, delivering information about the rights, talking with that specific, with both, with the victim and with the author of the injustice. Working on the author is very important. So making the author aware of what he or she has done. So, and this can be done with, if there are laws, for example, protecting against homophobia, then make the author available of what homophobia is, which are the laws, if any, but also to make the author aware of the feelings of the other.
It's important to create a dispute, to arrive to dispute.
Yes, to some extent, yes.
Thank you.
Ok, adesso andiamo al development of the alternative dispute resolution. Alternative dispute resolution started in the late 20th century in the United States and in England. Mainly started as reaction to the dysfunctions of the civil justice system. The alternative dispute resolution movement started with these fantastic ideas of creating new ideals, creating a cure, a panacea for all problems of disputants, but also was created with the idea of being a social movement. And at certain point was co-opted by government, because government thought that introducing alternative dispute resolution, mediation for example, making the mediation compulsory for the resolution of several disputes could help the states to save funding. However, there is nothing new in the alternative dispute resolution movement as it developed in the Anglo-American world. As I said at the beginning of my presentation, I said something about China. Why? Because if we look at several societies in Africa and in Asia, but also if we look at our societies in Italy, England, France, Spain, and so on, we can recognize that at all time and in all societies, the typical way to resolve disputes has been outside court. What is new in the alternative dispute resolution is that governments made and are making now, because we know that there is this encouragement, this focus on introducing alternative methods of resolution of disputes in all jurisdictions. So what is new is when the government made alternative dispute resolution part of the formal systems. Why? But this is another presentation, another lecture. Why? Because they think that in this way public fundings can be saved, which is not true. And also in doing so they are violating the rights of disputants. So there is again dysfunction in the civil justice. So we can say that the alternative dispute resolution movement as it is understood in the United States, in America, in England, and then from there come to Europe, can be seen as a consequence of several concerns against the civil justice system. However, even though governments, in particular to the late 20s, aimed at introducing alternative dispute resolution in the formal system, several were the critiques. And there are beautiful literature on that. But in summary, the critiques, the main critiques were, first, that in introducing alternative dispute resolution in the formal civil justice, the state could, courts in particular, could lose their power to educate people. A second line of criticism, more concerned with the sociological aspect of, and with more concern with equality of the parties, so in the use of alternative dispute resolution by government, a way to control parties, so eliare a longa manus of the state in order to control those small communities. And then a third very interesting line of criticism came from the feminist critique. And in particular, the starting point was in the United States, when several states made family mediation compulsory in cases of domestic violence. Feminist critique of mediation has been quite wrong and right in my view, because making mediation compulsory in cases of domestic violence would, in the word of feminist critique, reiterate abuses against women. This line of criticism was then retaken by those, in particular Delgado, who focused on the use of mediation by minorities groups. So, making mediation available for the resolution of dispute in the community and with the work of mediators trained in the community could violate the rights of some people in those communities, mainly women. In the development of alternative dispute resolution, but in my view, in what we are doing today, in what we will do tomorrow in our work as lawyers, legal scholars, mediators, and so on, a pillar is the access to justice movement. The access to justice movement was created by an Italian legal scholar, Mauro Cappelletti, who in England is compulsory. In Italy, when I did the civil procedure, I didn't study, but this is the rule of Nemo, Prophet, and Pater. So, is a revolution. In my view, access to justice was a revolution, and Cappelletti, together with several eminent scholars in different parts of the world, started this project in order to understand the barriers to access to justice and in order to find a solution to such barriers. What was the real aim? The real aim was to make justice effective. But what does effectiveness mean? Means to make equality in the instrument. Giustizia è effettiva quando tutti hanno gli stessi strumenti per avere accesso alla giustizia. Quindi non solo soldi, ma anche bravi avvocati, disponibilità di tutti i metodi di risoluzioni, corti vicine, corti aperte, anche di notte, non ritardi. Sì, è un mondo fantastico, però si può, almeno bisogna intenderci questo. The Access to Justice movement used these word waves. The waves of legal reforms, and the first wave of legal reforms aimed at introducing legal aid. The second one which is, in my view, the real revolution, is providing a legal instrument for making justice available to groups of people. And here we have the development of class action, public interest litigation, and so on. And the third wave, which is the one we are more interested in today, is called the access to justice approach, and aims at opening justice and making justice available. So Cappelletti argued, if courts cannot cope with all the workload, why don't we create other instruments? And here we have the inclusion, of course, of alternative dispute resolution. Access to justice movement is a revolution because it's a matter of equality, it's a matter of human rights. It goes beyond the three waves. In my view, is still evolving, and in particular through the work of the cause lawyers, all those lawyers as Avvocatura per i diritti LGBT, who work in order to make rights available. I really like one of the definitions of cause lawyers. Cause lawyers are those who subvert social structures. Then we have the litigation strategy, but also another aim of the access to justice, recent aim, is to make Supreme Courts, but also the International Court, for example, European Court of Human Rights, European Court of Justice, available, so open to direct access to citizens for the violation of dispute. Access to justice in its three waves has been very important for the LGBTI people. In particular, the second wave and the third wave. The second wave, briefly, because several class action, actually public interest litigation, have been filed in different countries in the world, ranging from the United States to Nepal, to South Africa, to India, and few laws discriminating on the basis of sexual orientation have been repealed. For our concern, the third wave is very important because it's ADR, and in particular mediation. So the third wave of the access to justice, mediation has been used, we will see in the afternoon, a lot by LGBTI people, in particular in the 70s in the United States, because it was the only way to resolve their dispute. Okay, typologies of response. Okay, now we have dispute. We are not happy, right? So we have to decide how to resolve this dispute. The primary forms of dispute resolution range from avoidance to alternative dispute resolution. Avoidance, yes, we can resolve a dispute through avoidance, just lump it, ok, non voglio sapere niente, ciao, fai quello che vuoi. Then we have apology. Apology is very important. It's important because we know it's the admittance that a wrong was made. It's also the admittance that, it's the admittance of the author of the wrong, that he or she committed the wrong. So it's a really good way to start any kind of resolution. Apology has helped also the resolution of several international conflicts. And there are some jurisdictions, Japan, for example, during the reform of the civil procedure law, it was this idea to introduce apology as compulsory first stage of any civil proceeding. So it's good. In our work, let's learn that we have to apologize. Then there is a self-help, and I wouldn't suggest you to use self-help. you know, self-help is easy because you just hit someone, you slap someone in the face, or you push someone, but it's not a good way to resolve a dispute, in particular for the consequences. Then we have the public decision-makings court. Finally, we have the resolution of dispute through alternative dispute resolution. And in particular, we have negotiation in which the parties face themselves, and mediation in which the parties are helped by a thirdly neutral and impartial party who facilitate the communication. Then we have arbitration in which the parties ask a third neutral and impartial party to impose a decision. So it's a sort of private umpiring. And then mixed processes. In the real world, all these methods have been mixed. So now we have, for example, in several cases, a first attempt of mediation, and then if the mediation does not succeed, the parties move to arbitration and so on. Now, my idea was to focus on negotiation and mediation. My hour is finished, so I suggest to have Professor Maglietta with his presentation, and then I will summarize what I have to say on negotiation. Is something in any case I would repeat in my presentation on same-sex couples. Okay, thank you.
Avete caldo? Era colpa mia. Che molto democraticamente ho chiesto di chiudere l'aria condizionata, perché non stavo la riaccendiamo.
Are you apologizing? Are you apologizing?
Yes.
Good morning. I have to beg your pardon since English is not my language, so I am sure that I make many mistakes, and I am very glad to have to conduct this speech partially in Italian and partially in English. And I invite you to break off me, to stop me, whenever you have some doubt or some question. Okay, let's begin. The first thing I want to say to you is that normally divorce is considered only a moment of stress, a moment of losses.